Welcome back to SCOTUS Oral Arguments and Opinions.
Strike one. But I'll give you some grace because you're married with 2 kids. Because, of course, you know that we changed our name to the High Court Report. We also refined the logo and created a LinkedIn page for people to follow there. What do you think of the updates? Let me know at SCOTUS.cases.pod@gmail.com.
Thanks to everyone for subscribing and supporting. I really appreciate everyone's contributions as we follow the Supreme Court. Keep on liking, subscribing, following, sharing, and rating.
Okay, let's get started. In this episode, first, I'm going to briefly talk about last week's oral arguments. Then I'm going to officially preview 2 cases: Fernandez versus United States, Rutherford versus United States, and Carter versus United States. Technically, that's 3 cases, but the Supreme Court consolidated Rutherford and Carter.
But first, let me just remind everyone that today, Monday, November 10th, the Supreme Court hears Landor versus Louisiana, Department of Corrections and GEO Group versus Menocal. In Landor, the court must confront Landor's lost locks, and when prison guards clip constitutional claims, the court must answer whether a person can sue prison guards for violating your religious rights after you're released.
In GEO Group versus Menocal, the Supreme Court must answer a procedural privilege, whether derivative sovereign immunity rulings create a fast pass to appeal. When ICE detainees sue private contractors for forced labor, can companies skip straight to appeal claiming the government told me to do it? With hundreds of billions in federal contracts at stake, this procedural fight determines whether contractor immunity claims bypass years of litigation.
Speaking of oral arguments, what did you all think of them? I found them fascinating. Here's a couple of takeaways.
I want to start with Coney Auto Parts versus Burton, the time trap tangle. The question about when invalid judgments become valid. Daniel Ginsburg, for petitioner Coney Island, argued that there's no time limits to challenge a judgment that was void from the start, such as failing to properly serve the underlying complaint. The courts of appeal support petitioner's position, based primarily on notions about strong historical record of maximizing the time for people to challenge void judgments. Lisa S. Blatt argued for respondent Burton. Ms. Blatt made a heavily textualist argument. This textualist argument crystallized in a colloquy where Ms. Blatt noted that modern Supreme Court interpretation focuses on plain text over circuit court traditions dating to the 1960s. I thought she did a masterful job of acknowledging that all circuit courts rejected her position. She softened by quickly acknowledging truth, then making a joke, then quickly pivoted to argue that since Justice Scalia joined the Supreme Court in 1986, the Supreme Court follows a more textual-driven process to decide cases. Under a textualist reading, her client Burton prevails.
Here's how it went. Justice Alito asked for Ms. Blatt's response to Mr. Ginsburg's contention that all of the courts of appeals decided this question against your position. Here's her response. So I think that's correct. I think these courts were writing, either now or at the time in a way that they were comfortable not following the literal text. Some of them acknowledge that they're not following the literal text, and this is just not consistent with the court's modern approach. I will say that most of these courts, I believe 5 of them, and the dissent trace back to this D.C. Circuit decision from 1962, Austin versus Smith, that just didn't even mention Rule 60C1. But since, the coming of Justice Scalia in 1986, the court has taken just a different approach to statutory interpretation. And we cite an example of, I think it's U.S. versus Brogan, where all the courts of appeals had ruled 1001 gives you a right to lie. And this court just said, we're going to overrule that. And I think just last term you ruled against a case I argued when all the courts had gone our way.
Mic drop.
Let's keep it moving. I'm sorry, Hensley fans, I'm going to need to give this case another listen and give you my thoughts.
Okay, the Trump tariff cases. Trump versus VOS, Selections and Learning Resources versus Trump. The constitutional clash over tariffs. The Trump tariff cases lived up to the hype. When I listened to oral arguments, my ears perk from the questions from the swing voters: Chief Justice Roberts, Justice Barrett, and Justice Gorsuch. They appeared moved by the lack of express textual support for the government's position and the ramifications of ruling in their favor. At the same time, Justice Barrett seemed to test whether other language may be read to authorize the tariffs. I wanted to touch on the questions of Justice Alito because they touch on core issues of this case.
Solicitor General D. John Sauer argued for the federal government. He argued principally that the words regulate importation includes the power to tariff. This phrase carried forward from IEEPA's predecessor, TWEA, which, under the same language, Nixon imposed international tariffs. Justice Alito asked General Sauer whether the federal government cherry-picked one part of Yoshida while disregarding another. Justice Alito pointed out that the Yoshida case, which Sauer relies on, also included limiting language, specifically that future surcharges must comply with Section 122 of the Trade Act of 1974, and that the Trading with the Enemy Act, TWEA, didn't grant unlimited power to fix rates of duty at will. He asked if General Sauer believed Congress relied on those statements as well when it enacted IEEPA.
Neil K. Katyal argued for the private parties. Justice Alito and Mr. Katyal had a fascinating exchange. It began when Justice Alito asked Mr. Katyal to focus only on the bare statutory language, regulate importation. He asked, if we disregard all of the rest, would you dispute that that would include the imposition of a fee? He then offered a hypothetical. If Congress allows the National Park Service to regulate admission to a park, can it impose a fee, especially one that raises revenue beyond the park's operating costs?
Mr. Katyal disputed that regulate includes a fee if it is revenue-raising. In the park hypothetical, he distinguished between fees that are not revenue-raising, e.g., just capturing the cost of government services, and those that are. If the fee does raise revenue, he argued it would not be permitted under the word regulate.
Justice Alito followed up. Do you think all tariffs are revenue-raising? He posed a second hypothetical. What if the president announces a tariff on a country, effective in 90 days, but an agreement is reached before it takes effect and no tariff is ever collected? Would that be a revenue-raising tariff?
Mr. Katyal argued yes. On its face, it is revenue-raising, even if it's ultimately not collected. He acknowledged edge cases, but said this case is not one, pointing to the government's own brief, which projected $4 trillion in revenue. Mr. Katyal reiterated his main point. It's very, very hard to believe Congress implicitly delegated this massive power through the word regulate.
Justice Alito joked about Mr. Katyal's legacy for reviving the non-delegation argument. He then asked seriously, wouldn't you agree that statutes that confer real emergency powers are often phrased much more broadly? Isn't that the very nature of an emergency provision?
Mr. Katyal responded that it cuts the other way, again citing Youngstown, emergencies require more precision, and Dames and Moore, where the court read IEEPA as not that open-ended.
Justice Alito offered a final counterexample, and this got Mr. Katyal to acknowledge the scope of the private party's position. Justice Alito asked whether Mr. Katyal would apply the same non-delegation argument for the 2001 Authorization for Use of Military Force, AUMF, which allowed all appropriate force.
Mr. Katyal said, of course not, and went on to distinguish the AUMF as an area of shared powers where the president holds inherent Article II military authority. He contrasted that with tariffs, which he argued are exclusively committed to Congress in Article I.
At bottom, Justice Alito appeared skeptical of the respondent's core legal theory. While some justices focused on the major questions doctrine or the history of TWEA, Justice Alito used hypotheticals to undermine what he may view as an illogical outcome. Congress authorizes the president to take total control over imports, such as an embargo or zero import quotas, but not the lesser tariff imposing power. Mr. Gutman, the Oregon Solicitor General, argued on behalf of the state parties. He had a bakery-minded phrase to Justice Kavanaugh's questions. Like Justice Alito, Justice Kavanaugh drilled down on the embargo, but no tariff argument. Justice Kavanaugh pointed out that the state party's position creates, quote, an odd donut hole in the statute. Mr. Gutman responded that it makes sense because, quote, the statute involves a fundamentally different power. It's not a donut hole. It's a different kind of pastry. Even Justice Kavanaugh gave Mr. Gutman his kudos for that line.
All right, that's a quick rundown of some of the happenings from the past week. Let's now dive into Fernandez versus United States, a case that could reshape how federal judges think about compassionate release and sentence reductions. This case cuts right to the heart of a fundamental tension in our criminal justice system. When someone claims they might be innocent and serving a life sentence, but they've already exhausted their traditional appeals, what can a judge do?
That's exactly the puzzle here. Joe Fernandez sits in federal prison serving a mandatory life sentence for a murder-for-hire conspiracy. The trial judge who originally sentenced him now has serious doubts about whether Fernandez actually committed the crime. But the Second Circuit says those doubts can never justify reducing his sentence. So we're talking about the collision between two different legal mechanisms. Traditional habeas corpus appeals under Section 2255, which challenge the legal validity of convictions, and compassionate release under Section 3582, which allows sentence reductions for extraordinary and compelling reasons.
Right. And the Supreme Court granted certiorari to answer this question, whether courts can consider potential innocence as part of their extraordinary and compelling reasons analysis, even when that same information might theoretically fit into a habeas petition. Let's break down the key statutory language that drives this whole dispute. Congress wrote in 18 U.S.C. Section 3582 C1a that courts may reduce the term of imprisonment if they find extraordinary and compelling reasons warrant such a reduction.
You know, when I read those words, extraordinary and compelling, they seem pretty broad on their face. Congress didn't define them, and they didn't create a bunch of categorical exclusions.
Exactly. And that's what makes this case so fascinating. The government wants to read an invisible limitation into that text, essentially arguing that certain types of information can never count as extraordinary and compelling, even if they actually are extraordinary and compelling in a particular case.
Now, Congress did create one specific limitation. In 28 U.S.C. Section 994T, they said that rehabilitation of the defendant alone shall not be considered an extraordinary and compelling reason. But notice, they called out rehabilitation specifically. They didn't say anything about excluding other categories of information.
That's a crucial point for the legal analysis. When Congress knows how to create categorical exclusions and does so in one instance, courts typically assume they meant what they said and didn't intend other unwritten exclusions.
Let's tell our listeners the story of how this case developed, because the facts are pretty compelling themselves.
Joe Fernandez goes to trial in 2013 in the Southern District of New York. He's charged with conspiracy to commit murder for hire and using a firearm in a crime of violence, both carrying potential life sentences. The prosecution's case relies heavily on testimony from a cooperating witness named Darge. Fernandez maintains his innocence throughout, but the jury convicts him on both counts. The trial judge, the Honorable Alvin K. Hellerstein, sentences Fernandez to 2 consecutive life terms, a mandatory life sentence on the conspiracy count, plus another life sentence on the firearm count. That's essentially a death in prison sentence. Now, Fernandez does what most convicted defendants do. He files appeals under Section 2255, challenging the legal validity of his convictions. Those proceedings actually succeed partially. They get his firearm conviction thrown out, but his mandatory life sentence on the conspiracy count stands.
Fast forward to 2021. Fernandez files for compassionate release under Section 3582. But here's an interesting nuance about his argument. He doesn't claim legal error. He's arguing that the combination of 2 factors creates extraordinary and compelling circumstances. Factor 1. Serious questions about whether the key witness, Darge, told the truth. Factor 2. Massive sentencing disparity. Fernandez got life, but his co-defendants who cooperated got much lighter sentences. One co-defendant only got 2 years. The district judge grants the motion and reduces Fernandez's sentence to time served, about 11 years. But here's the key quote from the judge's decision. A certain disquiet remains about the conviction. Along those lines, the judge admits being unsure that Fernandez was Darge's backup or that he was a member of the conspiracy. So we have a federal judge essentially saying, did I sentence an innocent man to die in prison? That seems pretty extraordinary and compelling to me.
But the Second Circuit reverses, joining what they call a near unanimous consensus that challenges to conviction validity are not cognizable as extraordinary and compelling reasons. Basically, the Second Circuit told the trial judge, you messed up by considering evidence about the soundness or reliability of the conviction. According to the Second Circuit, Congress should have spoken more clearly and definitively if Congress wanted extraordinary and compelling compassionate releases evidence to include evidence that undermines a person's conviction. The Second Circuit's reasoning here sounds like a variation of the major questions doctrine we heard in last week's Trump Tariff cases. If Congress wanted compassionate release to include evidence undermining convictions, they should have said so explicitly rather than burying it in general, extraordinary and compelling language. The Second Circuit seemed particularly concerned that people could circumvent the extensive process that Congress wrote for people who wish to challenge their convictions. Habeas corpus law sets out strict deadlines to file and onerous procedures to challenge a conviction.
The Supreme Court granted certiorari in May 2025 to resolve a circuit split on this question and answer the broader question about the scope of compassionate release authority.
Now let's dig into how each side frames their legal arguments, because this is really a battle over statutory interpretation methods.
Fernandez makes three main arguments. First, he says the plain language of extraordinary and compelling reasons contains no categorical exclusions. Both sides agree on what those words mean in the dictionary. Extraordinary means highly unusual. Compelling means forceful or urgent. And Fernandez argues that if you take those definitions seriously, some cases involving potential innocence clearly qualify. He's not saying every Section 2255 type claim would work. Most wouldn't meet the high standard. But in extreme cases, like when a judge believes he may have sentenced an innocent person to life, that's exactly what extraordinary and compelling covers.
His second argument focuses on congressional structure. Congress gave the Sentencing Commission authority to describe what counts as extraordinary and compelling, but with only one limit. Rehabilitation alone doesn't qualify. Fernandez says if Congress wanted to exclude other categories, they would have said so. The third argument addresses the government's main concern about conflict between the statutes. Fernandez says there's no real conflict because Section 2255 can't handle his actual claim. His motion combined potential innocence with sentencing disparity to argue for discretionary release. That's fundamentally different from seeking to vacate a conviction based on legal error.
Now, let's look at how the government pushes back. Their first argument centers on the idea that Section 2255 type claims simply don't qualify as extraordinary. They say such claims are extremely common in the federal system, and addressing them is just the ordinary business of the legal system.
The government's second major argument is structural. They claim Section 3582 is designed only for personal circumstances like age, illness, or family situation, not for challenging the underlying judgment. They point to the historical context, noting that before the Sentencing Reform Act, parole boards handled release decisions based primarily on rehabilitation and personal factors. They argue Congress intended Section 3582 as a limited substitute focused on similar personal considerations.
Their third argument centers on circumvention. They worry that allowing any consideration of innocence-type arguments would create an end run around Section 2255's strict procedural limitations. Things like statutes of limitations, bars on successive petitions, and procedural default rules.
Now, here's where Fernandez's reply brief tries to take on these arguments directly. On the plain language point, Fernandez emphasizes that his case doesn't involve repackaged claims of error. He's not alleging that his conviction was legally invalid. The courts found it was legally valid. He's making a completely different argument about the combination of innocence concerns and sentencing disparity. Exactly. The reply brief quotes the district judge's language about having strong concerns that Fernandez was innocent. That's not a legal error claim. That's a judge grappling with the possibility that he sentenced an innocent person to die in prison.
On the circumvention concern, Fernandez makes a clever distinction. He points out that there can be no circumvention when the claim doesn't even meet Section 2255's substantive requirements. His innocence argument can't be raised under Section 2255 because it doesn't allege legal error. And he addresses the flood of litigation concern with empirical evidence. The First Circuit allows these types of arguments, and they haven't seen a massive increase in filings. The extraordinary and compelling standard is so demanding that it naturally limits frivolous claims.
Looking ahead to oral arguments, what are you going to be listening for?
I'll be really interested to see how the justices react to the specific facts of Fernandez's case. When his lawyer talks about a judge believing he sentenced an innocent man to life in prison, do the justices seem moved by that? Or do they focus more abstractly on the legal categories? And I'll be watching for questions about workability. Do the justices think Fernandez's approach creates administrable standards? Or do they worry it will lead to endless litigation over what constitutes sufficient innocence evidence?
The precedent questions should be fascinating too. Will the justices see this as similar to cases like Prizer versus Rodriguez, where they've been concerned about circumventing habeas procedures? Or will they distinguish those cases because this involves discretionary sentence reduction rather than challenging conviction validity? Plus, I'm curious whether any justices will focus on the federalism angle. Most federal circuits reject the government's approach, but this gives the court a chance to provide uniform guidance for district judges nationwide.
This case could have enormous implications beyond just Fernandez himself. If the court sides with him, it could give trial judges significantly more discretion to consider the totality of circumstances in compassionate release cases.
On the other hand, if the government wins, it essentially locks in a very restrictive interpretation that limits compassionate release to traditional personal circumstances like age and illness.
Given the current court's emphasis on textualism and its skepticism of reading limitations into statutes that Congress didn't write, this could be a closer case than the circuit split suggests.
That's it for Fernandez versus United States. Let's move on to Rutherford versus United States and Carter and United States v. Carter. This case generated a solid number of amicus briefs.
13. For context, listeners, that's about double the number we saw in Fernandez versus United States. When you see that level of engagement from advocacy groups, federal defenders, and legal organizations, you know this touches some serious nerves in the federal sentencing system.
Absolutely. At its core, this case asks whether courts can consider the First Step Act's changes to gun sentencing laws when deciding if someone deserves a reduced sentence for extraordinary and compelling reasons. And here's why that matters. We're talking about thousands of prisoners who received much harsher sentences than they would today, thanks to an old practice called stacking that Congress eliminated in 2018. The question is whether that disparity alone can justify letting some of them out early.
So let's start with the exact question the court will decide. Whether, as 4 circuits permit but 6 others prohibit, a district court may consider disparities created by the First Step Act's prospective changes in sentencing law when deciding if extraordinary and compelling reasons warrant a sentence reduction under 18 U.S.C. Section 3582, subsection C, paragraph 1, A.I.
We're dealing with the same extraordinary and compelling reasons provision we just discussed in Fernandez. Here, 18 U.S.C. Section 3582, subsection C, paragraph 1, A, permits courts to reduce sentences if they find that extraordinary and compelling reasons warrant such a reduction. Let's talk about our 2 petitioners because their stories really illustrate what's at stake here.
First, we have Daniel Rutherford. In July 2003, he committed 2 armed robberies at a chiropractic office in Philadelphia. During the second robbery, he actually fired his weapon. Under the old sentencing rules, he got hit with consecutive mandatory minimums under Section 924C of Title 18 of the United States Code. That's the federal gun crime statute. Now, here's the key. Rutherford received 25 years for his second Section 924C conviction because of something called stacking. Basically, if you used a gun in multiple crimes during the same criminal episode, each additional gun charge carried a 25-year mandatory minimum.
Then we have Johnny Markel Carter, who was convicted of bank robbery and weapons charges. Same story, he got hammered with 25 years each for his second and third Section 924C convictions under the stacking system. But here's where the First Step Act of 2018 changes everything. Congress decided that stacking was unfair when all the crimes happened in the same case, so they eliminated it, but only for future defendants. People like Rutherford and Carter, who were already sentenced, got left behind.
So both men filed what's called a compassionate release motion, arguing that this disparity created extraordinary and compelling reasons for a sentence reduction. If they were sentenced today, Rutherford would face 7 years instead of 25 for that second gun charge, and Carter would face the same dramatic reduction.
Both district courts said no. The judges acknowledged the harsh disparity, but ruled that Congress's choice not to make the First Step Act retroactive meant they couldn't consider it as an extraordinary and compelling reason. Then came the appeals to the Third Circuit, and this is where the circuit split really crystallized. The Third Circuit affirmed the denials, even after the Sentencing Commission issued new guidance in Section 1B, 1.1, 3B6 that would have allowed courts to consider these disparities. The Third Circuit basically said the Commission overstepped its authority, that allowing courts to consider non-retroactive changes in law conflicts with the will of Congress. But 4 other circuits have reached the opposite conclusion, creating this clear split that demanded Supreme Court attention.
The Supreme Court granted certiorari in both cases and consolidated them for review. This resolves a deep and acknowledged circuit split that was creating arbitrary results depending on where you happen to be sentenced. Let's break down how each side makes their case, starting with the petitioners, Rutherford and Carter. Their first major argument is about congressional delegation. They say Congress expressly gave the Sentencing Commission authority to define extraordinary and compelling under 28 U.S.C. Section 994T, which states the Commission shall describe what should be considered extraordinary and compelling reasons for sentence reduction. They're leaning heavily on a 1977 Supreme Court case, Batterton v. Francis, which held that when Congress expressly delegates to an agency the authority to give meaning to particular statutory terms, courts must respect that delegation.
And here's their constitutional argument. Congress created the Sentencing Commission as a judicial branch entity with at least 3 federal judges specifically because they wanted to draw on the judiciary's historic expertise in sentencing policy. So when the commission issues guidance about what's extraordinary and compelling, they're doing exactly what Congress intended. Their second argument is really interesting. They say Section 1B, 1.13b6 actually harmonizes the First Step Act rather than conflicting with it. Congress made 2 big changes, eliminating gun stacking for future cases and allowing prisoners to file their own compassionate release motions for the first time.
Right? And they argue there's nothing inconsistent about Congress saying, we won't automatically resentence everyone, but courts can provide individualized relief in the most extreme cases. They cite statistics showing that of 1,381 compassionate release motions filed, only 43 prisoners got relief under Section 1B 1.13b6. That's a tiny percentage, about 3%. They're arguing this isn't opening the floodgates, it's providing a safety valve for truly exceptional cases.
Now let's look at the government's response, because they've got some powerful constitutional arguments too. The government's first move is to attack the plain meaning of extraordinary and compelling. They argue these terms have judicially administrable meaning that excludes Congress's deliberate policy choices about retroactivity. Their key quote is really striking. Congress's decision to leave Section 924C, offenders with final sentences stuck with their old sentences, is neither an extraordinary nor a compelling basis, let alone both, for a sentence reduction. The government argues that prospective application of criminal law changes represents the ordinary practice in federal sentencing, and what's ordinary can never be extraordinary. They're essentially saying the commission is trying to turn routine legislative choices into grounds for sentence reductions.
Their separation of powers argument warns that if courts can second-guess Congress's retroactivity decisions through case-by-case compassionate release, nothing would stop them from circumventing many other acts of Congress. Think about the implications. Could courts decide it's extraordinary and compelling that someone missed a statutory deadline by just a few days? Or that only some prisoners get retroactive benefits from other sentencing changes? The government says this opens a constitutional can of worms.
The government's second major argument focuses on the limits of the Commission's authority. While they acknowledge the Commission has some interpretive power, they argue it cannot treat extraordinary and compelling as empty vessels for its own policy views. They point out that 3 commissioners actually dissented from Section 1B, 1.13b6, criticizing it for going further than the Commission's legal authority extends and creating a seismic structural change to our criminal justice system without congressional authorization. Looking ahead to oral arguments, there are several key dynamics I'll be watching for. First, how do the justices react to the separation of powers concerns? The conservative justices have been very protective of congressional prerogatives, especially in criminal law. Will they see Section 1B, 1.13b6 as an impermissible end run around Congress's retroactivity decisions? I'm also curious about the textual analysis. Justice Gorsuch and others have emphasized that statutory interpretation should focus on what Congress actually wrote, not what it left unsaid. The petitioners argue Congress's silence doesn't create implicit limitations, while the government argues the statutory structure speaks volumes.
The practical implementation questions could be crucial too. If the court allows these disparities to count as extraordinary and compelling, how do lower courts draw meaningful distinctions? What prevents this from becoming a backdoor way to make the First Step Act fully retroactive? And there's the broader question about the Commission's role. This court has been skeptical of agency overreach, but they've also recognized that Congress sometimes delegates interpretive authority. The Commission's unique status as a judicial branch entity with judges might matter to how the justices view its authority.
I'll also be listening for questions about the statistics. Petitioners argue that only 3% success rate proves this isn't opening floodgates, but the government might counter that even that small percentage could encompass thousands of prisoners if applied nationwide.
This case really matters because it affects thousands of federal prisoners serving enhanced sentences under the old stacking regime. But the constitutional principles at stake extend far beyond gun crimes.
Exactly. We're talking about fundamental questions of separation of powers, the scope of agency authority, and how courts should interpret congressional silence. The decision could influence how compassionate release works across all types of federal crimes.
And remember, this is happening in the broader context of criminal justice reform. The First Step Act was the most significant bipartisan sentencing reform in decades, but it left thousands of prisoners behind. This case determines whether courts have any power to address those disparities case by case.
The timing is particularly interesting because Congress has been largely gridlocked on further criminal justice reforms. If the court sides with the petitioners, it essentially gives the Commission and federal courts more power to fill gaps that Congress hasn't addressed.
But if the court sides with the government, it sends a strong message that retroactivity decisions belong exclusively to Congress, regardless of how harsh the resulting disparities might be. We'll definitely be covering the oral arguments when they happen and the eventual decision. This is exactly the kind of case where the questions from the justices can reveal a lot about how they're thinking about these competing constitutional principles.
We'll of course host the oral arguments, so tune and listen. That's it for today's episode. Thanks for following us until the end. Thanks for listening to the High Court Report. If you enjoyed the content, please follow, rate, and share the podcast. Talk to you soon.